Say thanks so much to Ruth and colleagues, comrades at Queen Mary for organising this, but actually also for all the work you've been doing beforehand. And it's great to see so many people from different places here. So there's a lot to say. I'm going to try to be succinct and clear. I want to make 4 main points about the law and a couple of points about tactics. I'm going to start with the first point about tactics, because very much listening to what Julie has been saying about Man-Met and David from Birmingham and James from Queen Mary's experience, which is that there are roughly 3 kinds of tactics one can deploy in this kind of industrial act situation. The first is the sort of industrial tactics of sort of everyday industrial relations, which, you know, we're in the middle of a strike, so we know all about that. The second is around the sort of grievance process, which is using an institution's own processes to bring basically collectivized individual grievances. The third is sort of legal action. So what I'm going to be saying about the current situation of law of contractual employment and how that interacts with the law governing industrial action is going to possibly sound quite dry, and it will sound as if I am focusing on just the legal tactics, and I'm not. And I can see Lizzie smiling. So she's a professor of labour law as well, and we both worked in the same trade union firm 30 years ago. So it's very much about 3 tactics in sync and in tandem. But what Julie has been saying about, and David said, the threat is still there, even though there is operational compromise. It means that my end point is going to be, we absolutely need to instruct our union, which is in fact a union of members, to initiate legal action, both for our individual institutions, Queen Mary, Man-Met, but just collectively, because the uncertainty in the law, and there is, and I'll get to in a minute, is absolutely being exploited by quite aggressive tactics, which, if allowed to crystallise in terms of practice, will chip away at the very narrow scope there is for lawful industrial action, and separately for action short of strike action to be separate and meaningful in addition to strike action. So my end point is really, we absolutely have to leave today with a decision to really get UCU, because they're the ones with the resources to bring legal action, which would be in the name of our individual universities, but actually for the union as a whole, because this has repercussions for any, especially public sector, service sector workers, to be able to take strike action. We're not industrial workers. So when we withdraw our labour, it operates differently. So we're never going to be able to take action sort of strike again if we allow the employers to crystallise this as a practice in terms of, for example, you have to undo the impact of the withdrawal of your labour by rescheduling. If you allow that to be crystallised, you can never take strike action in the service sector. Mm-hmm. So my 4 key legal points are: first, a strike, a total cessation of work, will almost always constitute a breach of our contracts of employment, almost always. So we are very vulnerable when we take strike action. The effect of action short of strike on the concept ASOS, marking boycott and so on, the effect of action short of the total cessation of labour depends on its nature, but is almost also likely to be a breach of contract, and a breach of different parts of the contract of employment. Third point, the main consequence to follow from the fact that the strike, what we're doing today, is a breach of the contract of employment, is that the employer is under no obligation to pay strikers' wages. We know that. The no work, no pay principle is relatively uncontroversial, but its application in practice can be difficult. But in the situation we're in now of not paying for action short of strike, that is even more complicated. And we've basically got, and there is there's case law which pulls in 2 different directions, and there's definite gap in the middle which employers are exploiting. There is a fundamental and unresolved conflict in the law, in the case law, about what the legal implications are of deductions for action short of strike, which is a breach of contract. So most action short for strike, I think, will be breach of contract. David Mead, I think, is going to be talking later, but about the human rights in particular, but what you've got is the common law governs our contracts of employment. And when we withdraw our labour, we're in breach of contract, and our unions are liable for the economic losses that the universities suffer when they induce us to withdraw our labour, but they're protected because there's an immunity. But to the common law, and then there are statutory rights which enable unions to take lawful strike action if they get the balloting right. We know all about the balloting. But in addition, there's human rights law. And so what the employers are doing is they are prioritising the common law of the contractual employment, which has never been sympathetic to collective action. What we need to do is bring it back onto the terrain of what the statutory rights mean and the human rights mean. So basically, the end argument I would think we should be making is that if courts accept the interpretation of the impact of ASOS, which says that employers can deduct 25%, 50% or 100% of pay for action short of strike action, the impact of that will be to effectively nullify the statutory right, which that the gap, the space that is carved out of the common law hostility to us taking strike action. The statutory right will be effectively nullified. And I think Dave will talk later about the human rights. So from the human rights side, bringing into domestic law, the European Convention on Human Rights. So I don't know how much people need me to say about why. So a point made earlier by Harj about equality, about the substantive issues that we're fighting for. It's absolutely right and spot on. But in this terrain of the legal argument, we are not able to bring those substantive reasons why we're at pensions and workload into. What we have to focus on is the fact that when we withdraw our labour entirely, that we are breaching our contract employment. It's like if the employer just sexual harassment would be a breach of the contract by the employer, for instance. When we are working to rule, you think you're simply following the formal content of your contract. What has happened over the decades is that we're not bound just by the express terms of our contract, 9 to 5, your teaching land law. We're bound by implied terms, and those are terms which courts insert. Implied terms can be inserted by statute, like an equality clause between a man and a woman doing the same job have to have the same pay, even though the employer doesn't specify that. So statute implies terms into our contracts, but the common law of courts imply terms. And one of the really important terms that courts have implied since the 70s into employment contracts, duty of fidelity and duty to obey reasonable orders. So when we are working to rule, adopting this sort of slightly under the radar action, such as ASOS, effectively, we are very likely to be breaching an implied term of good faith, implied term that we mustn't sabotage our employers' operations, implied duty that we have to follow reasonable orders. And the question is, what action the employer can take in response to that breach. And what I noticed about the Queen Mary statement was it looked to me as if it had been lawyered up, because they had quite clearly said, we are refusing to accept partial performance. They can say that as much as they like. If in their action they are effectively accepting partial performance, then if they totally refuse to accept, my contract is I work 9 to 5. If I work 9 to 5, I'm not in breach of contract. If I leave at 3 o'clock, the employer can say, I'm not accepting your partial performance because you've not done those 2 hours. But if they allow me to come in and work till 3 o'clock and take the benefit of my working till 3 o'clock, or take the benefit of what I've posted up online already, they are in fact accepting partial performance. And that's where we can come in, because the case law that these are cases from the 70s and 80s. So effectively what you've got is a kind of ceasefire on employers using the common law, because as the common law stands, unfortunately, if they say they refuse to accept partial performance, they don't have to pay you for anything you've done from 9 till 3. If though, they are two things. If they are in fact accepting partial performance, they have to pay you for what they benefited from, the labour they benefited from. But a broader point, which I think deserves to be tested before the courts, is even if they have made that statement, we're not accepting partial performance, the practical impact of 100%, 50%, 25% deduction on the reality of the ability to take strike action, which has been endorsed by a lawful ballot, that point, I think courts will be amenable to listening to, because we've had recent cases where the courts are beginning to say, we don't have a right to strike in this country, we don't have a Bill of Rights, we don't have the right to strike codified in our constitution, but courts are beginning to say, you can't interpret statutory rights in a way against the trade unions, they're neutral, you have to take into account the European Convention on Human Rights. So I think this is definitely a litigible point, that the disproportionate deduction, one could say, is out of sync with the fact that they are entitled to make deductions to account for the service they're not receiving. Punishment is obviously off the table. Losses experienced by the students, well, if they can quantify the losses experienced by the students as losses experienced by the university, then perhaps. But the point is, they can deduct wages on the basis of the loss they have experienced as employers. So I'm going to stop there, because as you can see, there's just so much and I could go on for a bit longer.
Oh, that's brilliant, Diamond. Thank you so much.